No humans were harmed or even used in the video creation of this program. I created it from a script I wrote using a generative artificial intelligence platform and my own avatar of me. We hope you enjoy it. How is it that all our federal judges sitting in our majestic courts are bound by enforceable ethics rules, but Supreme Court justices sitting in this temple of justice are not? Hello and welcome. My name is Peter Afrasiabi. I am an intellectual property litigator at the law firm of One LLP with offices in Newport Beach and Los Angeles, California. My practice focuses on copyright, right of publicity, trademark, and related privacy torts. I also teach as an adjunct at the University of California Irvine School of Law, where I teach a Ninth Circuit Appeals litigation clinic with my students, as well as an advocacy and persuasion course. I have taught advocacy at the National Institute of Trial Advocacy and taught advocacy to new barristers at Oxford University in England. But keep in mind, all of the views expressed in this video are mine and mine alone, and are not the views of my law firm, the university, or any other academic institution or entity I work with. Today's program is an ethics program that looks at our broken ethics rules as they relate to the Supreme Court. We ask, why do our lower federal court judges get in trouble for ethics violations when Supreme Court justices get a free pass? Do we have an ethics crisis at the Supreme Court? Now, most of our legal media seems to focus on certain justices, creating a partisan feeling approach to the issue. But this program does not do that. We are balanced and look at ethics issues from both political sides of the court, as we have justices on the right and left in ethics dilemmas. And in today's program, we will also look at some interviews with legal experts on this issue to try to find an answer looking at all sides of the issue. You see here Lady Justice, blindfolded as an ancient and modern iconography to symbolize impartiality and objectivity in the application of the law. We are ultimately asking, just how blind is justice when it comes to ethics and Supreme Court justices? As we look at a variety of ethics issues that plague the court, and as in all our Curious Lawyer programs, we are straight facts, no partisanship. Thus, we explore justices and their violations from the political left and the political right. Turns out, sadly, our cast of justices from both ends of the political spectrum can be seen as playing fast and loose on otherwise applicable ethics standards. So, maybe that blindfold isn't so blinding as we shall explore and see. So get out your score sheets and we will keep track of our justices and whether they pass or fail the ethics tests. But first, and briefly, I want to tell you more about the Curious Lawyer series that we have created for you, a true curious lawyer. The Curious Lawyer series is a fun, educational, and entertaining walk down some of the off-the-beaten paths of law, areas that you do not experience in your regular practice day to day, but which are incredibly interesting and informative, and often yield new insights and valuable analogies or metaphors that you can work with in your practice. In this series, we take a variety of interesting issues and intersect them with the law to find fascinating, new, educational, and informative areas of the law to explore, and to better educate you about legal areas you may not know. For example, we have done programs on dog law where you get to think about your favorite furry friend and see how our relationship with dogs intersects the law, from tort to contract law, to even trusts and estate battles over dogs, and, of course, Fourth Amendment cases where there have been warrantless removals of dogs from homes for violating the leash laws. Or you can see the CIA Law Program, where you will see fascinating legal topics related to the CIA, secrecy, and the Freedom of Information Act, and where you will learn about that famous Hollywood movie line, "I can neither confirm nor deny." You will learn where it came from, and it turns out it was not Hollywood, but you have to watch it to learn who came up with it. We have also looked at whether there's a little sliver of Yellowstone National Park, where, due to a combination of the Sixth Amendment's vicinage requirements and the subsequent federal districts that were created by Congress to sit over the nation, whether that in fact has actually yielded a sliver of land, in our famed Yellowstone, that is free from federal criminal prosecution. Is it a perfect crime zone? Listen to that program and you will find out. And if you want to brush up on the Bill of Rights, we have a 10-part series with 1 hour devoted to each of the first 10 amendments to the Constitution, so that you, at the next cocktail party, can answer when a non-lawyer asks you what one of the amendments is all about. The one thing the Curious Lawyer series is not is boring. This is most definitely not your typical continuing education that is often technical, difficult, or stressful. So sit back and grab a cocktail, if you are so inclined, and let's get going in our fascinating, crazy, and at times shocking ethics exploration of our judges. Past is prologue, as Shakespeare wrote in The Tempest. And this takes us back to the early 20th century, where we had our own Tempest, where baseball collided with the law. Here you see District Judge Landis in the picture. He looked a serious guy. He was a federal judge in Chicago, and his salary was $7,500. Now he took the baseball commissioner job at a $42,000 salary, and he refused to step down from the bench. At that time, there was no ethics or bar rules to control the behavior or dictate this conflict. So there was a congressional impeachment outlet as the only regulatory mechanism, besides, of course, an ABA censure. Here's what the House said. What is to prevent baseball owners from going into the Supreme Court now and hiring every member on the bench? I think it affects the very soul of this government. That was Representative Benjamin Welty from Ohio at a House Judiciary Committee hearing in 1921. The Attorney General said Landis was within his rights, but based solely on political pressure, he ultimately resigned after 14 months of doing both jobs. This shameful exercise led to the first set of judicial ethics codes that we will shortly explore. The question to keep in mind on today's Ethics Odyssey, a century later, is where do we stand at the Supreme Court? Are we any better ethics-wise? Here is our agenda today as we explore ethics problems at the Supreme Court. We will look at the Senate Judiciary Committee investigation of 2024. We will look at the Supreme Court's self-exemptions from federal ethics rules and creation of soft rules. We will look at federal canons on judicial ethics, codes, and ethics rules from the early 20th century to today. And we will look at case law on ethics violations for regular judges to see how different the Supreme Court has treated itself. We will also look at pending proposals in Congress to address this ethics situation. Finally, in all this, we assess ethics case studies across the political party spectrum, from Justices Scalia, Ginsburg, Breyer, Thomas, Gorsuch, Sotomayor, and Alito. So, due to Judge Landis' situation, here's a quick walk through history as it relates to ethics rules and judges. There was no uniform federal code of canons until later in the 20th century. It was a state-by-state set of codes that judges were supposed to adhere to. In 1908, the ABA adopted the first model codes for lawyers. In 1926, the ABA finally proposed a model ethics code for judges. And in 1972, the ABA updated the codes. So let us now turn to the ethics codes that regulate all federal judges, all that is except the Supreme Court justices. The Code of Conduct for United States Judges, initially adopted by the Judicial Conference on April 5, 1973. This is the Federal Code of Ethics for federal judges. Judges who violate the Code of Conduct for Judges risk judicial discipline, such as censure, reprimand, or temporary prohibition from receiving new cases, or disqualification from an ongoing case. There are 5 canons, and we will review them. Canon 1 focuses as follows. A judge should uphold the integrity and independence of the judiciary. An independent and honorable judiciary is indispensable to justice in our society. A judge should maintain and enforce high standards of conduct and should personally observe those standards, so that the integrity and independence of the judiciary may be preserved. The provisions of this code should be construed and applied to further that objective. Here we have Canon 2. A judge should respect and comply with the law and should act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. A judge should not allow family, social, political, financial, or other relationships to influence judicial conduct or judgment. A judge should neither lend the prestige of the judicial office to advance the private interests of the judge or others, nor convey or permit others to convey the impression that they are in a special position to influence the judge. A judge should not testify voluntarily as a character witness. A judge should not hold membership in any organization that practices invidious discrimination on the basis of race, sex, religion, or national origin. And moreover, Canon 2A says as follows: an appearance of impropriety occurs when reasonable minds, with knowledge of all the relevant circumstances disclosed by a reasonable inquiry, would conclude that the judge's honesty, integrity, impartiality, temperament, or fitness to serve as a judge is impaired. Public confidence in the judiciary is eroded by irresponsible or improper conduct by judges, including harassment and other inappropriate workplace behavior. A judge must avoid all impropriety and appearance of impropriety. This prohibition applies to both professional and personal conduct. A judge must expect to be the subject of constant public scrutiny and accept freely and willingly restrictions that might be viewed as burdensome by the ordinary citizen. Because it is not practicable to list all prohibited acts, the prohibition is necessarily cast in general terms that extend to conduct by judges that is harmful, although not specifically mentioned in the code. Actual improprieties under this standard include violations of law, court rules, or other specific provisions of this code. So as you can see, this focuses heavily on public confidence in our judiciary, which drives the requirement of avoiding even the appearance of impropriety. Here is the third canon. A judge should perform the duties of the office fairly, impartially, and diligently. The duties of judicial office take precedence over all other activities. The judge should perform those duties with respect for others, and should not engage in behavior that is harassing, abusive, prejudiced, or biased. Now we can look at Canon 4. A judge may engage in extrajudicial activities, including law-related pursuits and civic, charitable, educational, religious, social, financial, fiduciary, and governmental activities, and may speak, write, lecture, and teach on both law-related and non-legal subjects. However, a judge should not participate in extrajudicial activities that detract from the dignity of the judge's office, interfere with the performance of the judge's official duties, reflect adversely on the judge's impartiality, lead to frequent disqualification, or violate the limitations set forth below. And Canon 5. A judge should not 1. Act as a leader or hold any office in a political organization, 2. Make speeches for a political organization or candidate, or publicly endorse or oppose a candidate for public office, or 3. Solicit funds for, pay an assessment to, or make a contribution to a political organization or candidate, or attend or purchase a ticket for a dinner or other event sponsored by a political organization or candidate. So those are the 5 canons that apply to federal judges. Well, sort of. As it turns out, the Supreme Court is exempted from those rules. This is because the Code of Conduct for United States judges applies by its terms only to lower court federal judges. And as public outcry has grown, here is the letter from Chief Justice Roberts to Congress to justify their exemption. While proclaiming they follow voluntarily the same rules lower federal judges must follow, they contend that they are different, and so as a result should not be scrutinized. Here is the letter. Quote, a recusal consideration uniquely present for justices is the impairment of a full court in the event that one or more members withdraws from a case. Lower courts can freely substitute one district or circuit judge for another. The Supreme Court consists of 9 members who always sit together. Thus, justices have a duty to sit that precludes withdrawal from a case as a matter of convenience or simply to avoid controversy. Individual justices, rather than the court, decide recusal issues. If the full court or any subset of the court were to review the recusal decisions of individual justices, it would create an undesirable situation in which the court could affect the outcome of a case by selecting who among its members may participate. End quote. We will explore that argument shortly, and both sides to it. But first, let's listen to Justice Kagan discuss the issue of congressional involvement and the limits that should apply, where we also hear some of the counter-arguments about why the Supreme Court is different. Listen here, as we can hear her in an interview she gave recently on this topic.
So there are limits here, no doubt. And so then there's this question, which is, well, in this sphere of ethical obligations, is this just like, yes, Congress can do it, or is this something where Congress has approached the limits of its power to affect what the court does? And I guess I would say as to that, now that I've gone on and on, I'm going to tell you, I'm not going to answer that question, but I'm not, because, Congress is considering these right now. Congress is an independent constitutional actor. I think Congress, when it decides whether to pass legislation, ought to, and hopefully, usually does, consider the constitutionality of its own actions, and is entitled to do that, I think. I wouldn't want to jawbone it while it's doing that. And so, I guess also I have in the back of my mind some feeling of who knows, something might come before us someday. But mostly I think, look, Congress is doing this. Congress should have, the right to consider for itself what it thinks constitutionally appropriate and otherwise appropriate. And, if it comes out with something, then we'll have a chance to say something about it. But I will say this, that regardless of what Congress does, the court can do stuff, So, one of the reasons we've never really confronted these, there's not a whole lot of law or precedent in this area of what Congress can do with respect to imposing ethical rules on the court. And the reason is that the court has acted voluntarily to subject itself to various rules. And one of the things that the Chief Justice sent to Congress this past spring was a statement that all 9 of us signed that talked about all the rules that we do follow, that we have decided to follow. And, essentially that we say we'll follow them just like other judges follow them, even though the court is, unlike other judges, a distinct, constitutionally created entity. Have undertaken to file financial disclosure reports and to limit the gifts we receive and to limit our outside income and to do a variety of things. And we've also made clear that we are guided by the standard code of conduct that applies to all other federal judges. Now, when we've said that, we have noted that there are certain ways in which we are different from other federal judges. I think that the usual example is that recusal operates a little bit differently, when recusal means that you will not be replaced by anybody. And there may be other differences as well. But we could decide to adopt a code of conduct of our own that either follows or decides in certain instances not to follow the standard code of conduct. And that would remove this question of what can Congress do, or at least, it would put it in a different light if Congress continued to act. And, look, it's not a secret for me to say, and there's been, that, we have been discussing this issue. And it won't be a surprise to know that the 9 of us have a variety of views about this, as about most things. We're 9 free-thinking individuals, and what the Chief Justice said most recently, and I want actually not to get out in front of the Chief Justice on this issue. But he said most recently, I was there. He was accepting a great award from the ALI, a deserved award, the Henry Friendly Award. And in his acceptance remarks, he talked about this issue, and he said that, he was determined, as we all are determined, to comply with the highest ethical standards, and that we were continuing to engage on the issue of what additional measures we could take to ensure that result. And so we are, and so we will. And this is, it's a hard thing to figure out exactly how we're alike and how we're different from other judges. It's a hard thing to get as much consensus as you can in the way that we like to do. But I hope that we will make some progress in this area of the kind that the Chief Justice talked about, and maybe put the question of what can Congress do or what can Congress not do, maybe take that out of play.
You heard that and can decide for yourself what you think about the rationale that we should all just trust them to follow the ethics rules other judges are forced by operation of law to follow, or the validity of the theory that they may have an ethics code that lacks an enforcement mechanism because they are just different and it is hard to figure it out. Shortly, we will see some cases that test the legitimacy of those asserted rationales. But this exemption was basically litigated in the court of public opinion more feverishly in the 2020s than before. And in 2023, after a lot of pressure, the Supreme Court self-adopted a similar code to the model code. And again, we have to say, well, they sort of did. The code they announced that they were bound by, it turns out, lacks any enforcement mechanism. That is, issues of bias or recusal do not get brought to other non-Supreme Court judges to assess, such as the Circuit Court Chief Judges. Instead, the justices get to self-determine their need to recuse for bias or an appearance of impropriety. But it is that lack of an enforcement mechanism that is so important to the idea of real ethics reform. Again, they adopted along the lines of what Justice Kagan said, a trust us rule of law for ethics. In response, the Senate Judiciary Committee undertook to study the issues and issued a report on the ethics of the Supreme Court, which raises serious questions about the validity of the just trust us theory. Now we will look at that ethics investigation and ethics report. Here, we have the investigation of the ethics challenge at the Supreme Court by the Senate Judiciary Committee from 2024 and its ethics conclusions. It was the culmination of a 20-month investigation, and the staff report features new information and a comprehensive analysis of the ongoing ethics challenges at the Supreme Court. Here's what they discerned. The highest court in the land can't have the lowest ethical standards. So long as Chief Justice Roberts and the Judicial Conference refuse to act, we must push for a legislative solution to this crisis to restore trust in the highest court. Here are some of the summary findings before we unpackage the individual justices and their various ethics cases. Finding 1. The Supreme Court has mired itself in an ethical crisis of its own making by failing to address justices' ethical misconduct for decades. Finding 2. Justice Scalia accepted lavish gifts from billionaires and others with business before the court for more than a decade. Finding 3. Justice Scalia misused the personal hospitality exemption to the Ethics in Government Act to hide or obscure lavish gifts. Finding 4. Justice Thomas has accepted lavish gifts from billionaires with business before the court for almost his entire tenure as a justice. Finding 7. Individuals seeking to influence the court have used gifts to gain private access to the justices. Finding 9. The justices regularly fail to identify obvious conflicts of interest that require their recusal under federal law. Finding 14. Having refused to address these myriad ethical issues, The court has demonstrated its inability or unwillingness to police its own ethical conduct. Here is the root conclusion. The committee's investigation demonstrates that the Supreme Court's current approach to ethics is fundamentally flawed. These shortcomings stem from several issues. 1. The willingness of some justices to violate federal law governing ethical conduct. 2. Decades of organizational failure by the court and individual chambers to adequately prepare the justices' financial disclosures or perform routine recusal reviews on pending matters. 3. Decades of organizational failure by the Judicial Conference to adequately perform financial disclosure reviews. And 4. The abject failure of the Judicial Conference to treat ethical misconduct complaints against the justices seriously and conduct any, let alone thorough, investigations. So here we start back in the day with Justice Scalia, and we will work through the justices and ethics findings first so you have the landscape and see also that we are covering the full spectrum. So here is what the report found. Justice Scalia regularly accepted luxury travel and lodging from wealthy benefactors and failed to report the gifts on his financial disclosures in contravention of federal law. From his confirmation in 1986 until his death in 2016, Justice Scalia took at least 258 subsidized trips, more than any other justice. Now let's move down the political spectrum, and we will look at Justice Breyer. Under federal law, any justice, judge, or magistrate judge of the United States shall disqualify himself when he knows that he, individually or as a fiduciary, or his spouse or minor child residing in his household, has a financial interest in the subject matter in controversy or in a party to the proceeding. Financial interest is clearly defined in law to include any stock ownership of a legal or equitable interest, however small. Justice Breyer did not recuse himself in this listed case here, despite his wife owning 750 shares in Johnson Controls, a respondent in the case. Justice Breyer participated in oral argument in the case. The day after oral argument, his wife sold all 750 shares. This sale occurred after a reporter contacted Justice Breyer's chambers about his wife's ownership of these shares. We will pause on those two justices from the right and left and come back to some other justices soon. But first, I want to discuss the ethics standards for disqualification of lower court judges, so we can then compare how cases play out for federal judges so differently to how they play out for Supreme Court justices when in these ethics dilemmas. This is the federal disqualification statute and its ethics standards for recusal to protect the integrity of the judicial system. Before we unpackage the law, let's look at the history of it. The idea of a code of conduct for the judiciary can be traced to the 1789 Judiciary Act, where Congress adopted the official oath for all federal judges, including Supreme Court justices. Under the terms of the oath, judges and justices were required to pledge to faithfully and impartially discharge the duties of the office. Following the Judiciary Act, Congress passed this first federal disqualification statute as far back as 1792. However, this disqualification statute applied only to lower federal judges, not the justices of the Supreme Court. So here is the law as it stands today. Any justice, judge, or magistrate judge of the United States shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned. He shall also disqualify himself in the following circumstances. 1. Where he has a personal bias or prejudice concerning a party, or personal knowledge of disputed evidentiary facts concerning the proceeding. 2. Where in private practice he served as lawyer in the matter in controversy, or a lawyer with whom he previously practiced law served during such association as a lawyer concerning the matter, or the judge or such lawyer has been a material witness concerning it. 3. Where he has served in governmental employment and in such capacity participated as counsel, advisor, or material witness concerning the proceeding or expressed an opinion concerning the merits of the particular case in controversy. 4. He knows that he, individually or as a fiduciary, or his spouse or minor child residing in his household, has a financial interest in the subject matter in controversy, or in a party to the proceeding, or any other interest that could be substantially affected by the outcome of the proceeding. 5. He or his spouse, or a person within the third degree of relationship to either of them, or the spouse of such a person, is a party to the proceeding, or an officer, director, or trustee of a party, is acting as a lawyer in the proceeding, or is known by the judge to have an interest that could be substantially affected by the outcome of the proceeding. In short, disqualification is required where impartiality might reasonably be questioned. The major rule that distills is this: disqualification for the appearance of partiality as viewed from the perspective of a reasonable, non-judge, thoughtful person. This has a public perception policy aspect to it to ensure the public perceives the system as fair and balanced, one of the rule of law. Thus, outward facts that could be construed as bias are required. This avoids the need to do a subjective heart and mind inquiry, to avoid needing to depose judges to see what is in their hearts and minds. And because they are allowed to avoid that subjective intrusion, the objective inquiry demands that in close cases or close questions, we err on the side of disqualification. And the test is robust in looking at bias or prejudice from an extrajudicial source. So let's now look at our lower court federal judges in a fact setting on ethics lines being tripped and compare it to some more of our justices in a moment, Justices Sotomayor and Gorsuch, so that we can see the ethics crisis at the Supreme Court in play. First, our normal federal judges, and let's take a look at the facts in this Ninth Circuit case. There was an indictment that charged a defendant with a corporate fraud scheme involving the inflating of his company's publicly reported revenue figures. He was convicted on all 18 counts. The judge refused to recuse himself, even though he owned stock in a company that was connected to the scheme. Remember our rule: a judge shall disqualify himself where he knows that he has a financial interest in the subject matter in controversy. A financial interest includes ownership of a legal or equitable interest, however small. The Ninth Circuit in this case held that, based on the unique facts that are before us, we conclude that the judge did have a financial interest. According to the SEC, AOL aided and abetted securities fraud by Homestore and improperly inflated its online advertising revenue based on the Homestore-related transactions by at least $1.5 million in the fourth quarter of 2000 and $7 million in the first quarter of 2001. In this case, the judge's rulings could potentially have had a financial impact on AOL. So let's see what our Supreme Court justices do when they have cases before them with money in companies, and where their rulings could impact the companies. This brings us to Justices Sotomayor and Gorsuch and the Penguin Random House Publishing Company. Each had publishing deals with the company. She had received over $3 million from her publisher Random House in royalties and advances. And he also had a book deal too, and has received over $650,000 in royalties. But then a case came before the court, specifically Nicasio v. Viacom and Penguin Random House. This was a copyright case involving their publisher. In that case, the district court dismissed copyright infringement claims brought by a children's book author against Penguin, finding that the works, about small trees with big dreams of becoming famous Christmas trees, are not substantially similar, and that no copyright protection is afforded to generic plots and themes. Those legal questions are significant ones for publishers. If that holding is right on the nature of substantial similarity within copyright law, then publishers escape liability. If, however, the test was wrongly applied, then the publishers face significant exposure. And so as the plaintiffs sought Supreme Court review, they both declined to recuse themselves in appeals to the Supreme Court for review of the case, even though they had a huge interest in ongoing royalties from the publishers, and the decision, if taken and reversed, would damage the publishers. We saw the AOL case in the Ninth Circuit where the judge tripped an ethics line. So is there any question left that if a lower federal judge who received $3 million in royalties from Penguin House, he or she could not be the judge in their copyright cases where the case poses huge exposure to them? It answers itself given the law of ethics here applied to all judges under binding laws. And so this highlights this ethics crisis at the Supreme Court. It highlights a double standard, and that is hard to square the circle on when it comes to judicial ethics from our highest federal judges. So now we will turn to another of our justices, and as you will note, this has been an inquiry about justices from all political corners. It is not a hit piece on the right or left. This will bring us to a case of ethics about a state court judge as ruled on by the Supreme Court, and then we will look at how Justice Barrett approached the same situation when she was under similar scrutiny. This is the case on your slide here, and here are the facts. A multi-million donation was made to a lower judge's candidacy, a state court judge, specifically Judge Benjamin. The judge then has a case with the entity who donated to his campaign, and the case involved liability for the entity that was potentially massive. In turn, Judge Benjamin refused to recuse, and the case then made its way to the United States Supreme Court. Our Supreme started this way. The court has identified additional instances which, as an objective matter, require recusal. These are circumstances in which experience teaches that the probability of actual bias on the part of the judge or decision maker is too high to be constitutionally tolerable. The difficulties of inquiring into actual bias, and the fact that the inquiry is often a private one, simply underscore the need for objective rules. Otherwise, there may be no adequate protection against a judge who simply misreads or misapprehends the real motives at work in deciding the case. The judge's own inquiry into actual bias, then, is not one that the law can easily superintend or review, though actual bias, if disclosed, no doubt would be grounds for appropriate relief. So how did it apply these ethics rules? It held that, quote, "We conclude that there is a serious risk of actual bias, based on objective and reasonable perceptions, when a person with a personal stake in a particular case had a significant and disproportionate influence in placing the judge on the case by raising funds or directing the judge's election campaign when the case was pending or imminent. Whether Blankenship's campaign contributions were a necessary and sufficient cause of Benjamin's victory is not the proper inquiry. Much like determining whether a judge is actually biased, proving what ultimately drives the electorate to choose a particular candidate is a difficult endeavor, not likely to lend itself to a certain conclusion. This is particularly true where, as here, there is no procedure for judicial fact-finding, and the sole trier of fact is the one accused of bias. And so, remarkably, the United States Supreme Court held not only that recusal was required, given the ethics rules, but indeed the Constitution and due process requires recusal because of the bias risk. The Supreme Court held, quote, "Our decision today addresses an extraordinary situation where the Constitution requires recusal." End quote. Pause on that holding for a second, and let us now turn to the Supreme Court's rulings when they are in the hot seat. We will ask, do they treat themselves the way they treated Judge Benjamin? This brings us to Justice Barrett and the Americans for Prosperity organization. This entity spent over $1 million to help get her confirmed. Then the same entity appeared before the Supreme Court in a case called Americans for Prosperity Foundation v. Bonta, case number 19-251. First, what was the case issue? To solicit contributions in California, charitable organizations must disclose to the State Attorney General's office the identities of their major donors. The state contends that having this information on hand makes it easier to police misconduct by charities. We must decide whether California's disclosure requirement violates the First Amendment right to free association. Justice Barrett did not recuse, and the court ruled that the organization did not have to comply with the California law. Notably, there were 3 dissenters, and the 6 in the majority did not all agree fully on one single rationale. Remember what the Supreme Court said about Judge Benjamin. His role was not just unethical, but actually violated due process. And it did not matter if the organization caused his election, because the inquiry is about public perception of propriety. Therefore, this appears, given the Judge Benjamin case, another data point pointing to an ethics crisis. Now we will go across the political spectrum from Justice Barrett to Justice Ginsburg. Here is the situation. Justice Ginsburg gave opening remarks at a lecture series named for her that was co-sponsored by the now Legal Defense and Education Fund, which regularly litigated abortion issues before the Supreme Court. 2 weeks prior to the lecture series, Justice Ginsburg had voted in a case on the side taken by the organization in its amicus brief. Justice Ginsburg then gave an interview to the New Republic, in which she offered commentary on Texas House Bill 2, a law that required physicians who performed abortions to obtain admitting privileges at a local hospital. In the interview, Justice Ginsburg was asked if state lawmakers could be trusted to safeguard abortion rights. She responded by saying, "How could you trust legislatures in view of the restrictions states are imposing? Think of the Texas legislation that would put most clinics out of business. In my view, both courts and legislatures have been moving in the wrong direction." Then, in the 2016 case Whole Women's Health v. Hellerstedt, the court ruled that the Texas law was unconstitutional. Justice Ginsburg did not recuse herself in the case, so let us now see lower court federal judges under actually binding ethics standards in similar situations to see if they have to recuse because of the ethics rules. This case study takes us to United States v. Cooley, reported at 1F 3 days 985 at page 995 from the 10th Circuit in 1993. Here are the facts. A judge appeared on TV to address widespread abortion protests and publicly said the protests were illegal. The judge even was quoted as saying that if anyone plans to come to Wichita, they had better bring a toothbrush. Then, after the protests got out of hand, various people were arrested and indicted. The same judge then had the case over the protests when criminal arrests were made, but the judge refused to disqualify upon motion of the defendants. The case went to the jury, and the defendants were convicted. On appeal, the 10th Circuit held that the ethics rules were tripped, and the judge should have disqualified. This also required vacating the convictions, the ethics violation being that serious. Here is what the appellate court said about the trial judge's TV appearance. Together, these messages unmistakably conveyed an uncommon interest and degree of personal involvement in the subject matter. It was an unusual thing for a judge to do, and it unavoidably created the appearance that the judge had become an active participant in bringing law and order to bear on the protesters, rather than remaining as a detached adjudicator. This is important to our ethics rules and canons we saw earlier. A judge can participate in public commentary, but if he or she does so, then they may well face ethics issues if cases on those issues come before them. This judge spoke publicly on the underlying case and facts, and thus fairly appeared biased, and so should have recused. So now we have another data point in our ethics exploration of ethics and judging, and the ethics double standard at the Supreme Court. For Justice, Ginsburg's commentary was fairly similar in discussing issues and impropriety on a party that appeared before her, even if her language was not as strident. Let's then now do a sidebar on some of our other ethics standards. With our first of 3 scenarios, we will unpackage that relate to judicial ethics. These additional case studies let us see how robust our ethics guidelines are for lower court judges. Here, and first, we look at a judge's prior relationship with parties or experiential connections to the case. This is Bryce v. Episcopal Church from the 10th Circuit. There, the judge was of the same religion as defendants. The court held that a judge having the same belief system on an associational bias theory is too tenuous to justify an ethics charge. But the next case involves familial connections to witnesses or parties, connections that can trigger ethics issues. This case study is United States v. Toohey. This was a sex harassment suit. The judge said this about the defendant. "He is an honorable man, and I know he would never intentionally discriminate against anybody." End quote. He refused to recuse, and on appeal, the Second Circuit held that it met the objective test and disqualification was required. Our next scenario looks at the issue of a judge's prior relationship with witness. This brings us to Fletcher v. Conoco Pipeline, reported from the 8th Circuit in 2003. First, our basic facts. The judge had been a friend of a fact witness who was a lawyer for 36 years. The judge was also a client of the lawyer witness's law firm in a current unrelated matter. The court held that fact pattern did not overcome a presumption of impartiality, and so there was no ethics violation. But this fault line on friendship is also not always so clear. Here we can see United States v. Kelly from the 11th Circuit in 1989. There the judge knew a defense witness, and the judge expressed some concerns on the record, but refused to step aside. Given that fact pattern, the court held that the ethics rules were tripped and disqualification should have followed then. The final third scenario brings us to the issue of a judge's prior relationship with an attorney. Here we look at United States v. Murphy, reported from the 7th Circuit in 1985. There, the judge was a close friend of the federal prosecutor. They had a joint family vacation planned for after the trial that prosecutor was in before the judge. The 7th Circuit held that level of friendship was unusual, and the objective test required disqualification on the merits of the test and facts. Back to today. Where do we stand in 2025 and on? And we will first do a quick recap. We have seen the difficult history of getting judicial ethics codes even on the books, and current ethics codes work well for lower judges. We looked at several cases testing ethics lines, of an appearance of bias across multiple scenarios for judges and lawyers. We saw what seems facially a double standard credibility gap for the Supreme Court as seen in specific case examples. We saw Justices Sotomayor and Gorsuch financial interest cases versus stock cases for other judges. We saw Justice Barrett money expenditures for her confirmation versus money for other judges to get on the bench. And we saw Justice Ginsburg speaking on hot public issues without recusal in a case on the very issue. And we saw that the rule was not the same for lower court judges. This is why legal reform is afoot at last to force a process of ethics compliance. Let's now look at the pending ethics legal reforms. Senator Whitehouse has introduced the Supreme Court Ethics, Recusal, and Transparency Act, which is co-sponsored by every Democratic member of the Senate Judiciary Committee. The act would require Supreme Court justices to adopt a binding code of conduct, create a mechanism to investigate alleged violations of the code of conduct and other laws, improve disclosure and transparency when a justice has a connection to a party or amicus before the court, and require justices to explain their recusal decisions to the public. We also have Senator Murphy's Supreme Court Ethics Act that would require the Judicial Conference to issue a code of conduct that applies to all federal judges, including Supreme Court justices. Third, we have Senators King and Murkowski's Supreme Court Code of Conduct Act. This would require the Supreme Court to issue a code of conduct for Supreme Court justices and publish it on the court's website. The court would also be required to designate an individual to process complaints that a justice has engaged in conduct prejudicial to the administration of justice or in violation of federal law or the court's code of conduct. The designated individual would publish the complaints. The Marshal of the Supreme Court would be permitted to initiate investigations to determine if a justice has engaged in misconduct. Fourth, we also have Senator Warren's proposed bill called the Judicial Ethics and Anti-Corruption Act of 2023. It would require the Supreme Court to adopt a binding and enforceable ethics code. It further places restrictions on gifts and privately funded travel. It also imposes an absolute ban on federal judges owning individual stocks and securities. Moreover, it heightens recusal transparency by requiring justices to issue a written response to recusal requests made by a party before the court. And it would also ensure the court is accessible to the public by mandating the live streaming of proceedings and restricting the court from sealing public health and safety records. Other proposals also have been put forward to address the ethics issues by trying to limit terms. For example, Senators Whitehouse, Booker, Blumenthal, and Padilla in October 2023 introduced the Supreme Court Biennial Term Limits and Regular Appointments Act of 2023. This law allows the president to appoint a new justice every 2 years within the first 120 days of the first and third years of their presidency. It thus introduces a system of 18-year term limits, which operates in tandem with the Supreme Court's appellate and original jurisdiction distinction. For an 18-year period, new justices sit for all Supreme Court cases. and only the 9 most recently appointed justices sit for appellate jurisdiction cases from lower courts, which represent the majority of the Supreme Court's docket. Under this model, all justices hear cases brought under the court's original jurisdiction, those in which the state is a party, and those affecting ambassadors, other public ministers, and consuls. But nothing has passed yet through Congress. The Supreme Court has not made itself subject to other judges deciding ethics issues against themselves. And so, the question we are left with is perhaps summed up by, where is Lady Justice in all this? Now we want to make sure we do not go overboard in addressing ethics reform as the question of who can enforce it and how it should be developed. Different opinions exist about who gets to enforce it against the Supreme Court. So let's watch this short video debate over the 2 viewpoints. This is from Johns Hopkins and a legal roundtable on the issue with legal experts and former Senator Jeff Flake.
Our third question is,
Here we go.
should external ethics codes apply to the court? Jeff Flake, yes or no?
I think my thing only says no here, so. But I think ethics codes should apply. External ethics codes, no. Remember, this is the independent judiciary. And if Congress as a body decided which ethics code it would impose on the court and perhaps change them over time depending on which way the court is leaning, that's not a good thing. So the court recognized that due to certain activity, certain members of the court, trips that were taken and whatnot have undermined, let's face it, the legitimacy of the court or the people's perception of the fairness of the court. And I do think that needed to be addressed, and it has been by the court. Now, some will argue, I'm sure it'll be argued here, that those are not enforceable or just self-enforceable and therefore not enforceable. But I think that there's even greater danger to politicize the court, to put the power in another body, the Congress here, to regulate what the code of ethics ought to be for the court. If you read through the code of ethics that the court has, they say they always had it, they simply needed to make it more explicit, which they have now. It's good. It addresses issues in terms of recusal and gifts and whatnot. It's good. It's just the question of, do we trust the court enough to implement it on its own? And I think that we should.
Thank you. Jamal Green, you're up next. Should external ethics codes apply to the court, yes or no?
Mine only says yes. Every judge in the United States is bound by a code of ethics. That is, every judge but 9. When we look at what happens in other federal courts, the question of whether an ethics code should apply to the court is less a question of should it apply. Of course it should, and in fact the court has a code of conduct already. The question is who should enforce it, as Senator Flake notes. With other federal judges, the way this gets enforced is it's by fellow judges, and then eventually potentially to the Judicial Conference of the United States. The objection to doing that at the Supreme Court level runs something like this, where the court kind of sits atop the judicial pyramid, and so putting some other body of fellow judges in judgment over ethics complaints against the court's justices puts them somehow on top of the court. The justices themselves seem to entertain some version of this objection. I don't find this very persuasive. Yes, the court is atop the judicial pyramid, but they're not above the law. Just as bribery laws apply to the Supreme Court and are adjudicated by others and can be, so too could a code of ethics be adjudicated by a committee of fellow judges. And if you're worried about whether the court is taken out of the process or something like that, just have them be able to review the decision of the other body, or have them voluntarily submit to its jurisdiction and help restore some of this record low public trust that the court is enjoying at the moment.
Thank you. Christina Rodriguez, yes or no? Should external ethics codes apply to the court?
So I would start by saying that there already are...
Can you say the word yes?
Yes, yes. I would start by saying that there already are external rules that apply to the court. Congress has passed the Ethics in Government Act, which requires disclosures of gifts. That's part of the reason why some of the justices have gotten in trouble for not disclosing travel that was paid for by their wealthy friends. The federal recusal statute also requires judges to recuse themselves when their judgment could be called into question because of a conflict of interest. Having an ethics code, and one that emanates from Congress, one that's publicly visible, is especially important for an institution like the court because it depends upon the public's confidence for its decisions to have effect. That is the crucial mechanism for ensuring that the Supreme Court's decisions actually become the law of the land. And the perception by the public that judges are the ones who police their own conduct is one that undermines public confidence.
So you saw their legal experts generally agreeing that we need ethics regulation and reform. To stay balanced, here in more detail are the counter-arguments to justify this state of affairs. The Supreme Court is a constitutional court, and the other federal courts are created by Congress. That is true, but Congress can control the Supreme Court's jurisdiction. The other two branches are subject to enforceable rules, and so the Constitution does not place them out of bounds from ethics regulation. If Congress can do it, so could they voluntarily do it. Second, in other courts, a recused judge can be replaced by another judge, but that is not possible at the Supreme Court. That is also true, but Congress could allow a circuit judge to sit by designation if it wanted. Or we could say, so what? If the court loses 2 or 3 justices for a case due to recusals, the rest decide it. The Constitution does not demand 9 justices decide every case, after all. One fix to this self-enforcement issue would be having a panel of circuit court judges decide recusal motions. Even if they cannot bind the court, their word would be powerful in the marketplace. For example, if 3 circuit judges told Justice Ginsburg she should recuse in that Texas abortion case we looked at, then she would probably listen to them, even if not forced by code to do so. And if she did not listen, the public and marketplace would take note, and that may spurn reform that is needed also. Ultimately, it seems that sunlight as a disinfectant is the best answer, and that the highest court in the land should be bound by the same enforceable ethics standards that the rest of the judiciary is bound by, for base logic reasons and public confidence reasons. Lady Justice should be blind, and importantly perceived by the public as blind too. Let's now conclude today's ethics program. We trace the ethics dilemmas of judges that led to the creation of our judicial ethics codes, from the crazy early days of federal judges double-dipping as baseball commissioners. We saw over time how these ethics laws and codes work, and work actually well, for our lower court federal judges in terms of holding the ethics lines by way of recusal. Some key poll stars for our judges are important to recall. 1. An independent and honorable judiciary is indispensable to justice in our society. 2. This focuses heavily on public confidence in our judiciary, which in turn drives the requirement of avoiding not just impropriety, but even the appearance of impropriety. We saw a variety of scenarios of the ethics rules on judges and participation in political issues that then appear before them. Family vacations with prosecutors and relationships with witnesses, where we saw the lines in these dilemmas and cases on either side of the line. And in all, regardless of which way the ruling on the ethics recusal issue came down, we saw robust judicial analysis by other judges of the propriety of the behavior, itself a marker of the ethics system working well. But we also saw across the political spectrum that similar ethics recusal requirement for lower court judges do not apply to the Supreme Court in comparable fact patterns. This is why we looked at justices from both the left and right to eliminate any political partisanship that may inhabit reporting we otherwise see on this issue. Thus, we saw that after pressure, the Supreme Court finally adopted a code of sorts, but it lacks a real enforcement mechanism, making it toothless. We explored the arguments on each side of this ethics debate, from Justice Kagan's interview to former senators and legal experts weighing in. And we saw the pretty brutal Senate Judiciary Report that itself concluded there is an ethics dilemma in our highest court. Remember the final key finding. Quote, having refused to address these myriad ethical issues, the court has demonstrated its inability or unwillingness to police its own ethical conduct. End quote. This at root is the issue. Finally, we looked at pending ethics bills in Congress aimed at addressing this issue, given the lack of enough self-policing by the Supreme Court. There we saw a variety of different but related ethics reforms bills pending, And we also saw none have passed yet, so it is seemingly now a question of depending upon Congress to force a system of enforceable ethics rules. Ultimately, one overarching conclusion is that the ethics rules for lower court judges work well. Our legal system has robust ethics rules and a means to enforce them in the lower federal courts. This helps ensure a rule of law-based system that the public can trust. But the Supreme Court has self-policed itself for decades, and it doesn't work well enough, as we saw in our many examples from both the justices on the right and left. We saw Chief Justice Roberts' justification, and at bottom, it does not appear strong enough to justify a non-enforceable code of conduct. After all, if we are to have ethics rules that have teeth based on the theory that we care about the ethics rules, then they should apply to all. And it seems even more appropriate that we demand our highest court in the land lead by example for the very ethics rules imposed on the lower court judges it supervises. There is something difficult to accept when the Supreme Court can tell a state court judge, as in the case of State Court Judge Benjamin we looked at, that he breached ethics rules to the point of denying core due process. But the same set of ethics standards do not even apply to the very court issuing that pronouncement on other judges. Ultimately, we seem to indeed have a Supreme Court ethics dilemma, a dilemma that requires the same rule of law applicable to all our other judges be also applied to our highest judges. After all, they are not and should not be above the laws of ethics. As we are all curious lawyers, I hope you've appreciated each side of the ethics debate here, as well as ethics inquiries into justices from each political side of the aisle, red and blue. We hope this has educated you on the ethics and recusal standards for federal judges, and leaves you pondering this critical question for our wonderful profession. Thank you for watching today's ethics program. Stay curious as a curious lawyer. And, as always, please reach out with any questions.